6 races living together.
Globespan is a Guyanese dialogue moving towards the realization of one nation in one Guyana. It's a platform that offers an all-inclusive discussion, with the pros, the cons, the ones that is taken aside, and the ones that stand in the middle. Globespan believes agreeing and disagreeing are part of the nation's building. Globespan believes that every Guyanese voice is part of the nation's building. As we span the globe for voices from the diasporas and those living home, we stand on our commitment that we are all Guyanese working towards one nation in one Guyana.
Coffee and Dr. Jagan, Bobby, she gave us our great sons. Rohan Kanhai, Coffee and Dr. Jagan.
As the world turns on its axis bringing changes, we as Guyanese must adopt to those changes for a better Guyana for all. Globespan stands on its axis with its belief that one nation, one Guyana, one destiny must include voices from all corners of Guyana.
Land of many waters with 6 races living together.
Welcome to Globespan Television, broadcasting live from New York City to all our listeners and to all our fans around the world. This program is made available by Mr. Noir Singh, the CEO for Globespan Television, and our technical directors are Mr. Ryan Gobin and Mr. Devin Bissoon. Tonight we have one of the most brilliant guests, and she is Miss Donna Street. Our title is the Director of Frontier Development of the Ministry of Foreign Affairs. But before I get to Ms. Street, I just want to tell our listeners an experience I had yesterday. I was at number 70 Back Dam, about 4 miles in from the public road, looking at all the beautiful scenery, the rice fields, the trees, the animals, and everything else. I was taken there by a good friend of mine, Mr. Joe Passad, who was the former advisor to the late Dr. President Chedi Jagan. He's also an engineer. And we spent a good time in the backlands yesterday. I was like back to nature, out of the concrete jungles in North America. It was a beautiful, beautiful scenery, you know. And it's an experience I will never, ever forget. Very, very nice. So I would encourage all of you Guyanese who live in the urban centers to take a trip in the rural areas and get to the back dam and to refresh yourself back with Mother Nature. It's very, very refreshing. It's very, very good. Thanks. Now, let me get to Ms. Street. Ms. Street, again, welcome to Globespan Television.
Thank you very much. Thank you for having me, Dr. Rose.
Now, our audience don't know you, but I came across you because you gave a beautiful interview or a brilliant interview to Culture News about 2 weeks ago. And when I read that, I learned a lot. I did not know much about frontiers, but I learned a lot from it. Now, before we dive into that, can you give us a little background of yourself?
Okay. Well, as you correctly said, I am currently the director of the Frontiers Department of the Ministry of Foreign Affairs. I am a career Foreign Service officer, having spent the last 16 years of my life in the Foreign Service. I think what people refer to as a specialized officer. That is to say that for the past 16 years, I've dealt with one set of issues and one set of issues only. I've been in the Frontiers Department and I have dealt with, well, the Frontiers Department is the department that assists the government to manage its relations with the Bolivarian Republic of Venezuela and the Republic of Suriname in the context of the preservation of the sovereignty and territorial integrity of Guyana. So I have a background in law and maritime, and I specialized in maritime international law in particular. So I've always done border issues for the past 16 years and maritime issues. So that is my background. I was the head of the department from 2012 to 2016. And then subsequently, I left for studies and I returned and I became again the head of the department from 2020 to today. So.
Okay, that's very good. Now, you mentioned about what the frontiers are all about, but on a daily basis, what your job entails. Our listeners would like to know that answer.
All right. So in addition, so the management of the relations between Guyana and let's say Venezuela or Guyana and Suriname, or I mentioned that the department also provides advice with respect to the rights and obligations that Guyana has in under international law of the sea. That means, so if I can start with maritime issues, I can say briefly that the Maritime Zones Act of 2010 of Guyana implements what is the 1982 UN Convention on the Law of the Sea. And so the Minister of Foreign Affairs is responsible for that piece of legislation. So with respect to maritime issues, what we do generally, we focus on the definition of Guyana's maritime space. We focus on what rights and obligations Guyana has in its maritime space, whether it relates to non-living resources or living resources of that area. We focus on what the government of Guyana can do in that area legally under its domestic law and under international law. And we focus on what other rights other states have or non-state actors have in that particular area with respect to whether it be the resources, whether it be, I think maybe passage through Guyana's waters, whether it be issues relating to the protection of the marine environment generally. So I think the department helps to keep in focus what the activities of Guyana are in this area and how we are really the interplay between what we are doing and what our obligations are, what our rights are. With respect to both Venezuela and Suriname, the management of the relations would entail, listen, not just you are aware, I think most Guyanese are aware that both of those countries maintain claims to portions of Guyana's territory. So in addition to managing the relations in a way that ensures that Guyana's rights in her territory are respected, we check to see what activities or either of those two countries are engaged in that would have an impact on Guyana's on the preservation of Guyana's frontiers and the exercise of Guyana's sovereignty in general over that area. And we also help to the extent possible, and I'm saying to the extent possible because currently we have bilateral cooperative relations with only one of those two states. And so the department assists in managing our cooperative relations with Suriname currently, for example. So we have in place what is a strategic dialogue and cooperation platform with Suriname. And so we have a number of areas in which we cooperate, including in health, security issues, immigration issues, political issues. Suriname and Guyana are, we're in the hemisphere, we're both member states of CARICOM, and so we kind of, in order to forge closer relations with that particular country, we have a mechanism in place. So the department manages that and facilitates engagements with Guyana and between Guyana and Suriname and Guyana and Venezuela. Currently, we have a matter with Venezuela before the International Court of Justice. Right. So the department we focus on, what's happening in Guyana and Venezuela.
I will come to that later on, but go ahead.
Yes. So we focus on that. We keep abreast with what is happening with the case. We provide information, we do research, we interact with the lawyers and technical teams and we kind of, keep abreast on everything that is happening in each of those. We're not just keep abreast, but we are actually involved in all of those issues that relate to the preservation of Guyana's sovereignty and territorial integrity. So it's a lot.
That's a lot. Now, to tell you the truth, I don't know of anyone in my entire life who was a frontier director or board dealing with you, the first person. So my question to you is this: what led you to study frontiers, or what caused you to become involved in frontiers?
Okay, let me say that I joined and there was a director before me there were many directors before me. And, but let me just say that in terms of my involvement, when I joined the ministry, I believe it was in 2008. Yeah, I think it was 2008. The beginning, yeah, the 2nd of January, 2008. We went through a period of orientation. I had done a bachelor's degree in law, and I had done postgraduate studies in international studies, I believe. And I was trying to learn languages or something like that. But during the orientation period, I had never personally wanted to become a criminal lawyer as such. I never had that particular interest. So I was in the stage of my life where I was looking for my particular niche. And so during the orientation sessions, we were involved, we were exposed to a discussion on Guyana's border issues and the issue of maritime international law in particular, and how it factors in Guyana's foreign policy, and of all of the presentations, because all of the departments made presentations to the new recruits, and of all of the presentations, the one area that I was interested in was that particular area, the area relating to Guyana's boundary issues and maritime issues in particular. And so the supervisor then was now Ambassador Keith George, or his High Commissioner of Guyana to Canada. And so he did a brilliant exposition of everything. And since then I was enraptured, and and I've been doing that ever since. I know other officers have the privilege, and it's not like, for me, it's a privilege to be in this department for that long. I know generally in the Foreign Service, officers are exposed to many, many different areas with respect to foreign policy and Guyana's interest in particular. And I want to say it's not that, and now when you're seeing what I have found is that my work in the Frontiers Department now does not only relate to matters relating to Guyana's borders in particular and maritime law in general, but it now encompasses additional areas of international relations and additional areas in international law, including, for example, international humanitarian law or migration law or environmental protection law. And so these are all various areas. The gamut of the work that we are currently involved in is tremendous. And so I've had nothing but opportunities for growth and development in this area of the Foreign Service. So I've never regretted it. I think I've been offered, a chance to do other things and to explore other areas. So far, I've just found tremendous satisfaction doing what I do.
Great. Now, my next question to you is this. Does a country have borders with the oceans or waters, or just with other countries?
Okay, so you have, let me put it the way it is couched in international law. Countries have maritime borders. So the extent of a country's jurisdiction, for example, does not only entail the land mass that the country currently has sovereignty over. So in international law, a country has to some extent jurisdiction over the airspace above it. And if you're a coastal state, then you have sovereignty, sovereign rights, jurisdiction, depending on what area you're talking about, in the maritime spaces. And so under international law, Guyana, for example, as a coastal state, is entitled to its internal waters, which it has sovereignty over. The internal waters of a state comprise all of the waters that are on the landward side of what is called a baseline in international law. And the baseline is formed when the land meets the sea at the lowest of the low tide. That is to put it very simply, because you know that, if, for example, you go to the seawalls and you see the water coming in on the beach, the land doesn't just disappear just because there's water. The land, it goes deeper. It becomes what is the seabed, subsoil, the ocean floor. And so a country is entitled to, for example, Guyana's oil and gas industries currently, we are able to benefit because of our entitlements in what is called our continental shelf, which is the seabed and the ocean floor, up to a distance of 200 nautical miles from the baseline. So there's the internal waters. There's a territorial sea, which is a distance of 12 nautical miles from the baseline. There's an additional zone called a contiguous zone. The contiguous zone is a zone that begins at the end of the territorial sea and goes for an additional 12 nautical miles. So the contiguous zone is a zone that is 24 nautical miles from the baselines. And then we have the exclusive economic zone, which goes to 200 nautical miles in the same way that the continental shelf does, except that the exclusive economic zone, whereas the continental shelf is a seabed and the subsoil, the ocean floor, the exclusive economic zone is the water column and the surface of the water going to the extent of 2.
Right. Good. Very good explanation. My other question to you is this, and this is what has been pouring in from audience during the week to me. How many frontiers Guyana has?
Okay, so we have a frontier with Suriname. We have a frontier with Brazil. We have a boundary with Venezuela. With respect to what is happening offshore, we have a delimited maritime boundary with Suriname that was delimited by arbitration in the same way, just to back up a little, in the same way that Guyana is entitled to those 200 nautical miles going out to sea. Right. Other coastal states, adjacent coastal states, are entitled to that, and international law requires that we delimit, that we show the line that separates Guyana's waters from Suriname's waters. So we have one delimited maritime boundary with Suriname that was settled by arbitration in 2007. We have potential maritime boundaries with Venezuela, Trinidad and Tobago, perhaps Barbados. We have potential maritime boundaries with those countries that we have not yet delimited.
The Atlantic Ocean. How far Guyana's sovereignty goes out towards the Atlantic Ocean?
Well, our sovereignty goes to 12 nautical miles, which is over the territorial sea. We have a different level of jurisdiction. The farther out to sea the maritime zone is, the less control the coastal state has over that area. So with respect to the 200 nautical mile limit of the exclusive economic zone, we have sovereign rights over the living resources of the in the exclusive economic zone. We have also, with respect to the continental shelf, we have, for example, sovereign rights over the non-living resources, for example, the oil and gas resources on the continental shelf. We have sovereign rights over those. And we have jurisdiction with respect, in accordance with international law, with respect to the extension of our laws to the extent permitted by international law in the exclusive economic zone, on the continental shelf, in the contiguous zone, in the territorial sea where Guyana has sovereignty. Our other states have a right to innocent passage through the territorial sea, but all Guyana's laws that apply on land apply in the same way in the territorial sea. So that
Great.
is a.
My next question is, and this came from a student who is telling me that she wants to study frontier as well. It's interesting. She says, how important are frontiers to countries like Guyana?
Well, they're very important. Your borders define the limits of your territory. Your borders define the applicable laws. Our frontiers, our borders are particularly important because of what is found within the borders. For example, apart from the human resources, all of the natural resources that are available to be used by the country for the development of the people and the country itself, it is important that borders are defined and limits are known and set so that we have access to whatever resources are found within those borders, so that we are able to apply our laws within our boundaries to protect the people that are there, so that we're able to properly screen those that come in and what goes out. And so your borders are important for all of those reasons.
Okay. Now, there's a question coming from me, and I want you to explain this for our audience to know. Are borders the same like frontiers?
Yes, basically. I mean, it's just the line, the border, and I think the nomenclature is important to some extent.
Right.
But in my opinion, not that much, because so the border is the line.
Right.
The frontier or the boundary is the line that the legal line, because it's not like an actual line that separates one country from another. The frontier, we have the frontier. The frontier could be a wider concept. It could include not just the line, but it could include the geography. It could include communities, so that we have frontier communities. The concept could widen as opposed to just a boundary line. So I think it could lend for a kind of wider interpretation of where your boundaries are and what your limits are. So I think so.
Okay, great. How is a frontier demarcated? Let's say our frontier between, but we know how it was done with Venezuela and Guyana, but let's say any two countries' frontier, the two countries agreed to say, well, this is the line, or this has been done by what?
If they can agree, on the international law, there are two ways. You can agree on where the line is, or that line can be adjudicated. You can bring the matter to, let's say, a court or an arbitration tribunal, and they could apply the necessary principles of international law to, or they can apply what the wishes of the parties are in determining where the boundaries are, or where the boundary is.
Okay. In Guyana, who are the people living on our on our frontiers? The Amerindians?
Mostly are indigenous peoples. Yes, that is true.
They live in our frontiers. Okay. Now, my other question to you is this: how protected are our frontiers?
Well, protected in what way? Militarily? I mean, protection, listen, there could be the fact of the matter that the borders are to a large extent properly defined on the international law means that you have more than an idea of where the border is. So that in itself adds some level of security to how we operate within the space that we operate in, because we are sure that we're allowed to operate in this space under international law. The physical protection of and international law also caters for the inviolability of that line that is determined by international law. And so even if there's no Guyana Defense Force soldier on one part of the border, that doesn't mean that automatically the border is inviolable. It can be violated. Sorry, you understand? So international law allows for it to be inviolable, even if there's not a physical presence. I mean, in cases of conflict and so on, in cases where there's disagreement over a border or a frontiers, then the actual physical protection of the border becomes very important. But to begin with, Guyana is certain where its boundaries are. Most of our boundaries have been settled under international law. And so international law also guarantees the right of the state to operate within those borders and to enforce its laws within those borders.
Okay, I'll turn to the Caribbean islands where they have no landmass between them. Do they have borders?
They have maritime boundaries. They have, each island is aware of its limits. They have, between those countries, there are maritime, because they're also coastal states, they're washed by the Caribbean Sea. And so they're also entitled to the 200 nautical miles and to the extent. And so international law caters for the delimitation of the maritime boundary between states with opposite or adjacent coasts. For example, Guyana and Suriname are adjacent, Guyana and Venezuela. But in some cases in the Caribbean, the states they would be opposite to each other, and so there is a possibility for the 200 nautical miles extension to clash. And so the law caters for the delimitation of those boundaries. Yes, it does.
Okay. Now, turning to Guyana and Venezuela, the border controversy, because some people said it's not a dispute, it's a controversy. What have you been studying pertaining to that border controversy? Have you been able to give advice to anybody, say the X, Y, and Z, if they ask questions? Like, what questions will come to you about the border controversy right now?
Oh my, well, now there's a lot of questions, but I think, let me just say, outside of the questions that are being raised, an hour ago, I was having a conversation with a taxi driver, and he was giving his opinion on what is going on. And I think one of the important things that I believe all Guyanese now know and understand is that the boundary with Venezuela was settled 124 years ago. And so everybody can relate easily to, oh, there was an award in 1899. And so this is one of the things that we've had, and this brings me to the issue of defining whether it's a border controversy or it's a border dispute and so on. Let me just say that even whether if it's a border controversy, let me just say that indeed the boundary between Guyana and Venezuela was settled in 1899, and it was not just it was the process, the outcome, the award was the process of the award was the outcome of a legally binding process plus a treaty that set the process in train. So in the treaty, which is the 1897 Treaty of Washington, the Venezuela and the United Kingdom agreed to certain rules with respect to how this tribunal of arbitration that was going to be set up, with respect to how this tribunal was going to function, what the tribunal will become, how many persons the tribunal will be comprised of, and what rules they would apply to settle the boundary. And so these are things that were agreed beforehand. And then the tribunal operated in accordance with the rules that were laid down by the British and the Venezuelans. And the tribunal arrived at a decision based on the agreement of Venezuela and the British. So that is important for Guyanese to know. And so the matter was settled in accordance with the rules that Venezuela agreed that that should be applied. And I go to and let me just say before I forget, I wanted to make one final point. Whether or not, so the position of the government is, and it is reflected in the 1966 Geneva Agreement, which many persons are aware of now, right, that what exists is a controversy over the validity of the award. And that is important because the international rules that will determine whether or not this award is valid would not be necessarily the same rules that would apply if there was no boundary in place. So if there wasn't a boundary in place, then then let's say, for example, the International Court of Justice would have had to determine a boundary and they would have had to apply certain rules. But there is a boundary in place and there's a legal document that established the boundary. So the set of legal principles that have to be applied to the determination of the validity or invalidity of the award are different from the determination of what the boundary actually is, if there was not a boundary in place. Was that simple enough, I think?
Yeah, that I think you did a good job in that. Now,
thank you.
The arbitral award signed in 1899, there was a commission established to mark off the demarcation. Now, Venezuela, as you mentioned, was represented by the United States. British Guyana then by Britain. And they all agreed it was settled.
They
and
did.
Both countries, both the United States accept and Britain accepted on behalf of those two countries, Canada and Venezuela and Guyana. Venezuela claiming, there was a Russian adjudicator there as well. Venezuela is claiming that the British bribed the Russian adjudicator. Have any one of you came across any evidence to that effect?
Venezuela itself has not come across any evidence to that effect. Okay, so that is an allegation. And indeed, you are correct. Venezuela had a choice and Venezuela chose. There was the United Kingdom on the one hand.
Right.
And then there was Venezuela and the United States on the other hand.
Right.
And so Venezuela opted to choose a United States judge, and the United States chose a United States judge too. And the United Kingdom chose 2 British judges, and those 4 judges together selected the Russian judge who became the president of the tribunal.
Right.
And so Venezuela was involved. And so when this issue of the memorandum arose, and the memorandum, I think it's available online. Anybody can.
I know.
No evidence included in that memorandum that would suggest that there was some collusion between among the judges. There is no evidence. There was no evidence that was suggested, and even though Venezuela holds this memorandum out as the reason why it is claiming that the award is invalid. Neither the Mali Provo nor the Venezuelans have provided any evidence to prove their claim of invalidity. And so there was, if you were following, if, persons are following the case closely before the court and you listen to the arguments, I think during our public hearings in November 2022, there was some attempt by Venezuela to prove this collusion. There was some evidence provided to the court, but the evidence was very weak at best. And so Venezuela lost also that round of oral arguments before the court. I think Venezuela was trying to prove why the United Kingdom was an indispensable third party to the case. And so it was the first time I've ever seen any attempt at proving collusion by Venezuela, but the arguments were not, they didn't fly.
But I want you to explain that again to our listeners and to all Guyanese. We had 2 British judges selected by the United Kingdom, 2 American judges selected by the Americans.
And Venezuela chose one, the Americans chose one.
But Guyana did not have no say because Guyana was a colony.
Colony, exactly, at the time.
And those 4 justices or judges selected a Russian judge to be the president to chair everything else.
Yes.
And how the decision was made? All of the 5 justices made the decision, or the 4 and handed to the Russian judge?
Well, from what I recall, that's a good question. The decision was made, the president had to sign off on the decision. So there was, I like the question because there was some suggestion by the government of Venezuela that there was not included in the award any reason for the decision. So it was not possible at the time for us to know what kind of deliberations happened during the period when the judges were coming to an agreement as to what. But what we have evidence suggesting that during the arbitration, of course, we have communications from by the lawyers, communications among the judges, communications in the government, and so what we are very certain of was that there had to be some degree of compromise, and so there was, which is obvious and normal and natural when a panel of judges is arriving at a decision. There's some discussions and negotiations, and of course the judges Venezuela's interests were represented by its judges. The British interests were represented by the judges. And so the president was there to hand down the final decision and to kind of balance out and weigh what the arguments were from the lawyers on both sides. And the judges were there to kind of put legal teeth, more or less, to what the arguments were. And so there were judges that represented both the interests of the parties, and eventually they all came to a compromise, which is nothing new. It's not suspicious, because that is how a court arrives at a decision. You listen to both parties and you balance and you weigh the arguments and arrive at a decision that is just and reasonable. And so that is what happened.
And I want you to expound on this a little more. All 4 justices, the 2 from the United States and Venezuela involved. Venezuela chose a judge, I think, by itself too. And yes. The 2 from Britain, the decision was unanimous.
Yes.
I want you to explain that to the people, to our listeners. Because it's a learning process for our listeners. Most of them just hear from Venezuela, but they don't know what
It means that they agreed. And it means that they all agreed that this is what was just and equitable in the circumstances, the president as well as the four other justices. And not only was the decision unanimous, the decision was accepted and welcomed by Venezuela especially. Our records suggest that the award was handed down on the 3rd. By the 7th, on the 7th of October 1899, one of the Venezuelan diplomats and lawyer, I believe, who had participated in the case, said, "Greatly indeed did justice shine forth." And I know that quotation because it's in so many of our publications, you know. Okay. And then he said that we set ourselves the principal aim of acquiring the mouth of the Orinoco, and that is exactly what we got. And they were very, very pleased with the decision at that time because they had a principal intention going into the arbitration, and they were able to secure exactly what it is that they wanted out of the process. The British had, you're already aware, I think most Guyanese are aware, far-reaching claims still to the Orinoco and all of that. The court said no. The Orinoco, the mouth of the Orinoco goes to Venezuela and this portion, and the Essequibo region goes to the United Kingdom. And because both parties agreed in the Treaty of Washington that they were going to consider the results of the arbitration as a full, perfect, and final settlement, the British complied with its obligation.
And I want you to explain to our listeners as well, the case before the court, the International Court of Justice, ICJ, is not about the land claim, is whether the 1899 arbitral award was valid.
Yes, and that is, and I always have my Geneva Agreement because it's so important, and because Venezuela has been working very hard at deliberately misinterpreting the Geneva Agreement. It's always important to, and the agreement, and I always say, it's a very short agreement. It has just a couple of articles. And 2 pages actually when you print it out. 6 articles. No, not 6. That's a protocol of Port of Spain. It has 8 articles. Very short. And so Article 1, I'm going to read. Well, there are 2.
Go ahead.
There are 2. Okay, so there are 2 issues that can arise for discussion based on a reading and interpretation of Article 1. So Article 1 says that a mixed commission shall be established with the task of seeking satisfactory solutions for the practical settlement of the controversy between Venezuela and the United Kingdom. This is the important part, which has arisen as the result of the Venezuelan contention that the arbitral award of 1899 about the frontier between British Guyana and Venezuela is null and void. So that is what defines what the controversy is. It is Venezuela's contention that the award is null and void. That is what Article 1 of the Geneva Agreement says. Right. And so that is what it is. Nowhere in the Geneva Agreement does it say that there is an acknowledgement that Venezuela has a legitimate claim to Guyana's Essequibo region. The word Essequibo is not mentioned in the Geneva Agreement. As a matter of fact, Article 5 of Geneva Agreement says that nothing that goes on in the context of the discussions under this Geneva Agreement, nothing that goes on shall be construed as either a diminution of Guyana's rights over her territory or of Venezuela's rights over her territory. That was awarded to them in the 1899. So it means that it does not affect Guyana's sovereignty over the Essequibo, and it does not affect Venezuela's sovereignty over the Orinoco and, you know, the mouth of the Orinoco River or anything like that. Nothing that goes on in the context, and that is what it says specifically. So it's always interesting that Venezuela would seek to impute alternative interpretations into the agreement when in fact the agreement is, and it's very, very clear, I think both in English and in Spanish, you know? And so that is what the controversy, and that is what when Guyana applied to, made its application to the court, the first thing that we asked the court to do was to adjudge and declare that the award is valid. And that is the essence of our matter before the court. And let me just say that under international law, even if the award were invalid, it does not automatically mean that the Essequibo region would go to Venezuela.
That's a very good point. And I
It
hope our
is.
listeners are taking that into consideration.
That's, you know, the International Court of Justice has said, first of all, there's a principle that is sacrosanct. The principle of the stability of boundaries is sacrosanct in international law. And the court has on occasion also said, the International Court of Justice, that even if the instrument that determined the boundary is invalid, it does not automatically mean that the boundary itself is invalid. The court has said that the boundary has a life of its own outside of the existence of the instrument, whether it be a decision of the court or agreement of the parties, outside of that instrument. And so that is really very important. That's why Venezuela, I think Venezuela knows this. That's why they know that they don't have a case that could properly withstand.
I'm coming to that question, Ms. Street. Tell our listeners why Guyana has such a strong case and Venezuela has such a weak case.
Well, let me start with Venezuela, and this is a point that we already discussed. Right. Venezuela has never been able to prove, despite being given several opportunities to prove its claim of nullity of the award, it has never been able to prove that the award is invalid, not within the discussion, and it has an opportunity to present evidence right now to the International Court of Justice, and it has opted not to. Well, we don't know if they're going to continue their participation in the case, but they have indicated to the court last November that their appearance does not necessarily mean that they recognize the jurisdiction of the court, but they do have the opportunity to present whatever evidence they have to the court so that it could withstand legal scrutiny. You know, and so they have been shying away from that. Guyana's case is extremely strong because, one, Venezuela participated fully in the legally binding process that led to the determination of the boundary. Not only did Venezuela participate fully, Venezuela agreed that whatever the decision was going to be full, perfect, and final. Venezuela participated also fully in the demarcation of the boundary in accordance with the award. Venezuela signed the 1905 agreement relating to the map of the boundary.
Right.
Venezuela incorporated into its domestic laws, in accordance with its domestic laws, the boundary as defined by the award. Venezuela respected the boundary for 63 years after the boundary was demarcated, was defined. And when Venezuela first claimed that the award was invalid, Venezuela has not been able to prove, Venezuela has opted not to try to prove that the award is invalid. So there's no, and as I said just now, even if the award is invalid, it does not automatically mean that Essequibo belongs to Venezuela. It does not. That is not the way international law operates. And so Guyana has a very, very strong case. Guyana has a very, very strong case. And that is why the International Court of Justice is the most suitable, peaceful means of determining the validity of the award. And the decision of the court is going to be final and binding on both Guyana and binding again on both Guyana and Venezuela. And so after then, there will be hopefully no more plausible reason, well, not to indicate that the memorandum is plausible, but following the decision of the court, there will be no more, I think, reason to question the validity of the award, because then the allegations have withstood legal scrutiny.
Now, Guyana's case rests on the fact that Venezuela accepted the award in 1899. Venezuela is now claiming that the award is null and void. Venezuela accepted the fact that it will present its case to the International Court of Justice. Now, when a country claiming that they don't recognize the laws or the ICJ laws, why would they want to present their case to the same body?
Well, that's a good question. That would require me now to consider what is the thinking of the government of Venezuela on this issue. And I myself am at a loss to know what it is they were thinking, except that I will say this. Venezuela is claiming that Guyana brought the matter to the court unilaterally, and that Venezuela does not recognize the unilateral jurisdiction of the court, the jurisdiction of the court in such a manner. And Venezuela has also said that that there are many other countries that do not recognize the unilateral jurisdiction of the court. That is to say that one party cannot just bring another party without their consent. And it's an important issue to raise and to clarify, because we hear often that this is not what Venezuela wanted, that first of all, that the Secretary General did not get the agreement of the parties to bring the matter before the court, and Venezuela prefers dialogue, Guyana prefers the ICJ, and so there's some need to clarify what the position is. Guyana did not bring the matter unilaterally to the International Court of Justice. First of all, the Secretary General chose the International Court of Justice as the means to settle the issue. And now, how did the Secretary General get the mandate to choose the International Court of Justice as the means of settlement? And I want to refer you and your listeners to the Geneva Agreement again. And this time I'm going to read from Article 4, paragraph 2 of the Geneva Agreement. And I'm going to, and it is such a simple agreement, and sure everyone who hears will understand. So, first of all, let me just come back to a point that I made with respect to the Mixed Commission. So the Mixed Commission was established in accordance with Article 1, right?
Right.
Article 4.1 of the Geneva Agreement says that if within a period of 4 years from the date of this agreement, the Mixed Commission should not have arrived at a full agreement for the solution of the controversy, it shall, in its final report. That means the Mixed Commission had 4 years to do what it needed to do. And what it was given the mandate to do was to seek a satisfactory solution for the practical settlement of the controversy between Venezuela and the United Kingdom. And so you still hear Venezuela talking about this satisfactory solution for the practical settlement. But that was the mandate, that was a specific mandate only of the Mixed Commission. And so the Mixed Commission had 4 years to fulfill that mandate. And then the agreement says that if it did not do that, then in its final report, it shall refer to the government of Guyana and the government of Venezuela any outstanding questions. Those governments shall choose without delay one of the peaceful means of settlement provided in Article 33 of the Charter of the United Nations. Good. So the first is that when the life of the Mixed Commission came to an end, if at that time there was no satisfactory solution, then that issue of the satisfactory solution for the practical settlement goes out the door. What is the new means of settlement that comes in? That is Article 33 of the UN Charter. Article 33 of the UN Charter says that the parties to any dispute, the continuance of which is likely to endanger the maintenance of international peace and security, shall first of all seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, or any other peaceful means of their own choice. And so the issue of the practical settlement for a satisfactory solution goes out the door with the Mixed Commission when it's expired in 1970. And the Article 33 now, any means of settlement in Article 33 comes to the fore and for the parties to choose. So the agreement says that those governments shall choose without delay one of the means of peaceful settlement. That means Guyana and Venezuela needed to agree on a means of peaceful settlement under Article 33. Now, and I go to the operative paragraph, Article 4.2 of the Geneva Agreement. It says that if within 3 months of receiving the final report, the government of Guyana and the government of Venezuela should not have reached agreement regarding the choice of the means of settlement in Article 33, then they shall refer the decision as to the means of settlement to an appropriate international organ. Then it says, upon which they both agree. Or failing agreement on this point, that means if they could not agree on an international organization,
right,
to the Secretary General of the United Nations. So they could not agree on any means of settlement under Article 33 of the Charter, and they also did not agree on any international organization. And so the agreement says that if they couldn't agree on Article 33 and they couldn't agree on an international organization, then that choice of the means of settlement would fall to the UN Secretary General. And that is the consent. By signing this agreement and agreeing to the Secretary General choosing a means of settlement, Venezuela consented to the International Court of Justice being the means of settlement, because judicial settlement is mentioned in Article 33. And the agreement says that the Secretary General, shall choose from Article 33, and he can choose and so on until the controversy has been resolved or until all of the means of peaceful settlement there contemplated have been exhausted. Now, the Secretary General chose another means when we started out in 1990. He chose the good offices process. That is another means of peaceful settlement. And
Right.
when Secretary General chose good office, he did not require for the agreement of the parties because they already agreed that since they couldn't agree, then he would choose.
Right.
And so that is important for us to know and to kind of debunk this false narrative that the government of Venezuela has been propagating about them about the Secretary General needing he already had their agreement. The agreement is found smack in Article 4.2 of the chart of the Geneva Agreement that they incidentally are saying is the only instrument that should be used for the settlement of the controversy. That is correct. And Article 4.2 says how that settlement should come about and that the Secretary General should choose. And the Secretary General did choose. So the further agreement of Venezuela, further agreement was no longer necessary. This is legally binding. The Geneva Agreement that they hold on to for dear life is legally binding both on Venezuela and on Guyana. And just to say that their skewed interpretation of the Geneva Agreement did not find favor with the Secretary General and his battery of lawyers when in 2018 he referred the matter to the court, and their interpretation of the agreement also did not find favor with the International Court of Justice when they challenged the jurisdiction of the court.
Well said, Ms. Street. I don't think anyone can put it better than you did there. Now, no one can dispute the fact that President Ali has done an outstanding job at international forums, bolstering Guyana's position or stance on the border controversy. Prime Minister Phillips did that to the Organization of American States. Now, Venezuela they have actually isolated Venezuela from the Western world. What Venezuela is doing now is going to Russia. You saw that in the papers. To seek help. Even Cuba refused to issue a statement. We're supposed to be an ally to the Caribbean, to CARICOM, but also to Venezuela. So Maduro's desperation, I think, led to the December 3rd referendum. Even to that did not work in his favor because they're saying only 10% of people went out and vote. But Venezuelans normally do not go out and vote. If you look at most elections in Venezuela, it's just between 32, 35% of people will vote in the regular elections. They did not go out and vote. So my question to you now, all that President Ali has done, Prime Minister Mark Phillips, they've done. How you think Venezuela, well, you don't have to get into the heads of Maduro, but how you think Venezuela is taking all of this? Even though an International Court of Justice ruled that even the referendum, you must not trample on any rights pertaining to Guyana. What do you think left for Venezuela to do? Let me say this to you before, though. I rule out military. It will not invade Guyana militarily. Because Maduro is not that stupid. He saw what Putin is facing in Ukraine. He saw the condemnation from the rest of the world, most of the countries. Even China called for us to call for both countries to settle peacefully.
And Russia. Russia said, peaceful settlement in accordance with international law.
Yeah, well, Russia went on and said that foreign powers should not intervene, but Russia will want to intervene. So what do you think left now for Maduro to do or Venezuela to do?
I think that's such a tough question, but let me say this. Venezuela has always been saying, even the referendum was in accordance with international law, But international law is clearly defined. I think the principal thing to do is to begin to act in accordance with international law. And there are some clear principles of international law that Venezuela has been breaching, that they could begin to observe. For example, the principle against the threat or the use of force against the sovereignty or independence of another state. That's a principle in the UN Charter. The principle of the peaceful settlement of dispute, that's another recognized principle in the UN Charter. Observation for the rule of international law. And in particular, Venezuela is a party to the United Nations. Therefore, the UN Charter is applicable to it. Article 94 of the Charter speaks to states abiding by a decision of the court that the court has already declared is final and binding on both Guyana and Venezuela. So Venezuela knows that any decision of the court is binding on her. Venezuela could begin to observe those principles of international law. Another, apart from the friendly, maintaining friendly relations among states, neighborly relations, where Guyana cannot pick up and go anywhere, Venezuela cannot move. We are stuck together forever. We could begin to develop friendly relations. That's a principle that's an option that the government of Venezuela has, that it can pursue in terms of really, I want to say, that is an option that it can pursue if it will regain the respect and admiration. Venezuela was once a glorious country. If it will regain the respect and admiration of members of the international community, Venezuela could begin to observe these very basic principles and tenets of international law, I think.
Some say, political scientists, that when a leader is weak internally, that leaders look for some problem externally to create a problem in order to boost his sagging popularity at home. I said this is a case for Venezuela right now because the opposition has taken a more drastic rule and said that they will take Essequibo, and they're up in the polls and elections are due next year. Another set of thought is saying, school of thought is saying, that Venezuela is doing this because it wants the US to come in and release the sanctions grip on them so they can strive. That's the two political aspect of it. But before anything could happen, do you think Venezuela must have to respect international law and the ICJ? Rogue states normally do not respect international law. North Korea, Syria, that other country there, the Ayatollah country, they don't respect international law.
Yeah, that's true. And it's unfortunate because when governments of the international community has a way of responding to rogue elements, and almost all of the time when the international community responds, those that suffer are not the government and the people that hold on to power.
True.
It is the population.
That's right.
It is the people that suffer, who suffer. And so that is the unfortunate thing about this whole scenario. We cannot say for certain that the majority of Venezuelans approve the actions of Maduro. We've heard from the leader of the opposition that the referendum was ill-conceived and it was ill-supported by the people of Venezuela. I also heard her say that Venezuela has a legitimate case and that should be presented before the International Court of Justice. So there are others, maybe they're loud, maybe there are more voices in Venezuela with that type of reasoning, but we cannot hear that because maybe there's a stranglehold on those voices. There's no doubt that the Venezuelan people feel that Essequibo belongs to them, but it takes another legal process to undo a legal process if you can, So Venezuela wishing away the validity of the arbitral award is not going to make it invalid. Venezuela saying that they don't accept the boundary is not going to make the boundary any less legitimate or any less valid. And it's not going to in any way affect the fact that the fact and the law, that the boundary was indeed settled by a legally binding process, which Venezuela participated fully and consciously, and which Venezuela observed for several decades. So it's just unfortunate that people are suffering.
Based on your experience, your legal knowledge, and knowledge of the frontiers or border issues, do you think Venezuela will eventually come around to accept the ruling by the International Court of Justice?
Probably not. But that does not affect its legality, its legitimacy. And what will be important for Guyana is that, to the extent that there are other countries in the international community that are observing and that are currently unsure of the status of the boundary or what the discussion or the dispute or between Guyana and Venezuela is, I think the decision of the court that the majority of states that subscribe to the basic tenets of international law respect the International Court of Justice and respect the United Nations system. And so it will be important for us, once the decision of the court comes out, that the members of the international community can be further, well, I wanted to say, well, they can become, well, not just become aware, but the legitimacy and the strength of Guyana's arguments will be further confirmed once the decision of the court comes out. And so that's important for us. It's important for investor confidence. It's important for how Guyana is viewed in the international community. Currently, there's some states saying, well, why don't you talk? Well, we don't need to talk because we've been talking for 20-something years on the very issue. And the matter that Venezuela wants to talk to us about is the matter that Venezuela agreed could be taken to the International Court of Justice. And while we were talking for the 20-something years, Venezuela was entered into those discussions in very bad faith. Venezuela used force against Guyana. Venezuela used intimidatory tactics and all kinds of actions to try to force Guyana to concede its patrimony, and it did not work. It's just a situation of bullyism and to some extent greed.
I would like you to explain to the younger people who might not know about this award, which dates back to 1899, that for 63 or 64 years, yes, Venezuela accepted the decision by.
Yes, they produced maps showing the boundary as defined. They produced stamps showing the boundary as defined. And in 1962, when the issue of Guyana's independence was being discussed in, I believe it was the 17th session of the UN General Assembly, Venezuela raised the issue of of the settlement of the boundary. Right. And I want to say that, the British foreign minister at the time made it very clear that even though they were going to provide an opportunity for Venezuela to satisfy itself that there was no collusion, they were not entertaining any reopening of the boundary because they considered the boundary to be settled. And it is my understanding from reading the history that the matter of Venezuela's claim was going to be an hindrance to Guyana's peaceful transition to independence. And so that is why there was need to, in order for us to contain that hindrance and to have it dealt with separately, the Geneva Agreement was signed so that, and then Guyana 3 months later moved to independence. And once Guyana became independent, Guyana became a party to the Geneva Agreement. And so I believe it was from Article 4, the discussions concerning the Venezuela's claim and the controversy would now be between Guyana and Venezuela.
Now, a lot of the folks today believe because oil was discovered in the Essequibo region, Venezuela is making the claim. But as you said, and you know, this claim goes back to 1962.
Yes.
But it was done periodically here and there and so forth, but not as vicious as now by Maduro.
That is
So
true.
I want you to tell our audience why Maduro is making this claim now and why oil has a play when Venezuela, they say, has over 300 billion barrels of oil and Guyana has just about 11 to 12 billion.
Reserves in the world. Venezuela sits on the largest proven reserves in the world.
Right. So let our listeners know that it is not, you don't believe it's because of the oil he's making this claim. It got to be some other justifiable reason or because he's weak at home or something. But to make the claim now and to do the intimidating tactics and bullyism on Guyana, that will not lead Venezuela in any way respectable to the rest of the world because, as you said, all the countries came down heavily against Venezuela. All the world organizations, the Commonwealth of Nations, CARICOM, the OAS, the EU, all of them came down heavily against Venezuela. So Maduro, as I said, is going to Russia. But what I want you to tell our audience that Venezuela's claim to the border is not based on any facts or it's not factual. It's based on what Venezuelans believe to be theirs.
And you know, that is what they believe. But the important, and you know, Venezuela had an opportunity. I don't know if you listened or if your audience listened to the judgment of the court on December 1. And the president of the court, while she was reading the summary of the judgment and then eventually the order, she provided the history of the situation between, and the history of the situation of this controversy between Guyana and Venezuela is the history as, I mean, it's not that the court was partial to Guyana, but those are the facts of the case. That is what happened. Venezuela actually participated. She actually accepted the award, and she actually took steps to implement you know, the award and the definition of the boundary and to ensure. And you know, and so this is what was interesting. And over the years, you know, Venezuela has graduated her claim to from the invalidity of the award to then, you know, the entire Essequibo region then belongs to Venezuela. Then, I mean, in 1968, the waters off the coast of the Essequibo region belongs to Venezuela. Then, more recently, the waters off the coast of the Essequibo, the Demerara, and the Berbice area belongs. And so there's just this unreasonable enlargement of the Venezuelan claim based on no facts. But Venezuela, it's so unfortunate because from where I sit, I think Venezuela is a bully. I think Venezuela thinks, and one of the things that, you know, the Venezuelan president has been saying is that Guyana is being influenced. You know, he talks periodically about Exxon, about the US. Now he's talking about the Southern Command, and it's really insulting to Guyana as a country because I believe that it would appear that they're under the impression that Guyana is not capable as a sovereign state of defining what its national interests are. And and pursuing a strategy to achieve those national interests when that couldn't be farther from the truth. You know, the fact that Guyana has not succumbed to the intimidation, to the tricks, to the tactics. The fact that Guyana's diplomacy has worked extremely well over the past 50 years to ensure that Guyana's sovereign territory remains under its control, and the fact that the court said, listen, this is that you cannot undo this. You can do nothing to disturb Guyana's peaceful, exercise of sovereignty over her territory. The fact that we have been able to define our interests, to use the tools that are available legally, because we cannot afford to be a bully and to threaten. Guyana is a small state. You know, I was at the car wash the other day. I was talking to this Brazilian gentleman who lives in Guyana, and he said, but oh my goodness, Guyana is so small. It's just little chicken. And then he put up his face. And really, in comparison to Brazil and Venezuela, Guyana is a small state, a very small state. So it's so unreasonable that without any legal basis, the government of Venezuela would seek to expand and to use threats and intimidation. And when Guyana, as a small state, uses the tools that are available to it internationally, our strategic relations that we have built over the years, we have used that to protect ourselves. That is being condemned by the government. So we should be left without protection. We should not have the right to, it's no longer self-determined. We should not have the right to the peaceful exercise of sovereignty over our territory. That's the position of the government of Venezuela. That's essentially what they're saying. You should do nothing to protect yourself. You should just lay back and be bullied and just surrender your territory to Venezuela for no proper reason, for no legitimate reason, because the law is clearly on our side. You know, the facts of the case as articulated by the president of the court are the facts as Guyana see them, and those facts cannot be disputed by Venezuela. Venezuela could try to twist those but I think the international community can see exactly what is going on. I think that is why Guyana has had the tremendous support. And yes, the government is doing an extremely good job right now. I think more people, and this has never happened in my 16 years of being in the Foreign Service and dealing with this issue. So many people are now familiar with the issue. So many people, Guyanese people are able to talk with confidence. Well, this is what the situation is, and people talk about the education, but we've always known, and the public sensitization on exactly what the issue is. So to some extent, persons have always known that there's an issue. Now they're familiar with the details of the issue. But one thing has always been clear and consistent in terms of the education that has been provided to the Guyanese people. We know what the shape of Guyana is. We know that Guyana, has 4 natural regions, 10 administrative regions, 3 counties, Essequibo is the large, Essequibo River, Demerara, Berbice. Every child in Guyana knows that. And so there has been education on the overall issue relating to what the territory of Guyana is and how Guyana exercises sovereignty over that territory. Now, the nature of the Venezuela's claim, how ridiculous it is, that is something that is that more and more members of the population are familiarizing themselves with. So I think the information, the sensitization campaign
has worked.
Yes, I think so.
Now, the question, I'm a bit disappointed though in CARICOM. Not one of the leaders, CARICOM issued a statement that Venezuela should abide on the international sub, but not one of the leaders have gone as far as Brazil, President Lula said that if Venezuela attempts to invade Guyana, he will break all ties with Venezuela. And I expect something like that to come from CARICOM, and it did not. You know, so I'm disappointed in CARICOM. Like somehow, I don't know if we not ask them to go and fight, but said if Venezuela, then CARICOM will break all ties with Venezuela. But I know they're getting doing trade with Venezuela and so forth. A mere monthly statement that Guyana and Venezuela should not be aggressive. You know, I am disappointed in CARICOM. I don't know about you. I'm disappointed in
CARICOM. I understand what you're saying, CARICOM, but CARICOM has been a very consistent support to.
I understand.
And you know, and you know, the heads of they've always supported you know, they supported Guyana in terms of the preservation of our sovereignty, our territorial integrity. And once we were able to have the matter brought before the court, CARICOM supported the ICJ process and continues to support the ICJ process, and has often called on Venezuela to participate fully in the process so that the matter could come to an end. We're dealing with and so we're dealing with states with individual interests, and Guyana, and they have, I think it's very fair to say that they have looked out for Guyana's interests. I mean,
well, I'm saying they should have gone further though, but it's okay. I understand. And you hit the nail on the head when you say they're dealing with individual interests. I understand they're doing a lot of trading with Venezuela, oil and gas and so forth. But, you know, there comes a time when you really have to stand up and say, you know what, Venezuela, if you should ever make that attempt, CARICOM will break all ties with you or something. But it is what it is. What can you do? You know?
Listen, there is always an opportunity to, and I'll tell you, there's always an opportunity for restoration of relations. And I recall when I joined the department, we had a very relations between Guyana and Suriname were not that close. But over the years, we have been able to, following the arbitration process, we have been able to work to build and restore that relationship. And so now, you know, we have a functional, I mean, we remain two states, individual states with individual interests, you know, but I think the relationship has improved significantly from then, when there was hardly any mechanism for cooperation and dialogue, to now, you know, you're at the point where, you know, you can pick up the phone, you can, so there is always an opportunity. This is my experience. And so this is why I'm thinking there's always an opportunity for relations to be improved. And we're going to go past this process, and what happens then, you know, we're going to move on from this current tense period, and then we remain neighbors, and CARICOM remains, you know, a sister to Guyana and a friend of Venezuela for those, you know, so it's a very delicate balance, I think.
Like everything else, all this tension will pass us by in the near future. We're coming to the end of the program. You want to tell us, is your closing statement? So far, the program ran out, an hour and a half gone by.
Yes, I did think that it was kind of long, but you're right. The time, you know, when we're talking, these issues are often, they're very interesting to me at least, and I hope that the viewers found our discussion very interesting too. I just want to say that with respect to this issue, it is the intention of the government to see the resolution of the controversy with Venezuela, to see it come to an end by the very process that we're currently utilizing, which is the process before the International Court of Justice. We believe it is the most peaceful way for the controversy to be settled. And of course, I already said that, Venezuela agreed, and whether or not Venezuela, and this is what the court has said, and this is what the law is, whether or not Venezuela participates fully in the court process, she's still bound by the decision of the court. And we are confident that the court will find, based on the evidence that Guyana has provided to the court, that the court will find that the award is indeed valid, and that Guyana remains the rightful, I don't want to use the word owner, but the state that rightfully exercises sovereignty over the Essequibo region and the entire Guyana. And I just want to say too that the Ministry of Foreign Affairs has information relating to the controversy on our website. There's a section that relates to the controversy. The judgments of the courts, the discussions, the oral hearings, the information relating to the process before the International Court of Justice, also available online on the International Court, on the ICJ's website. So you could type in Guyana versus Venezuela, and you will see what Guyana's arguments are, the documents, what Venezuela's arguments are. And so, of course, the Ministry of Foreign Affairs remains available to provide any kind of assistance, requests for information that are, that people from time to time would reach out to us in order to acquire. So we're here, we're available, and we're accessible.
Thank you.
Thank you for having me.
I want to say that President Ali has made one of the most brilliant decisions to meet with Maduro, but not to discuss the border issue.
You made that very clear.
The maintenance of peace in the region. The region has been known as a zone of peace, and no one should destabilize the region. Yes. Maduro should think twice. And I know he's thinking hard, and I know he has no intention of destabilizing the region because the odds are against him. But it's a very good decision President Ali has made, because you need to sit and talk face to face and said, look, this is a zone of peace. The Western Hemisphere is known for its peaceful solutions and resolutions to all conflicts. Yeah. This is before the court. Let the court decide. But at the same time, let us maintain peace in the region. Yeah. And that's a good decision President Ali has made. Very, very wise. With that said, I want to thank again Mr. Noor Singh for making this program available, Devin Bissoon and Ryan Gobin for being our technical directors here. And I want to thank you, Ms. Donna Street, for such a wonderful display of your knowledge, so that every Guyanese tonight will go to bed and say, yes, we have learned something about our frontiers. We have learned something about Guyana and Venezuela border controversy, and we have learned something about what to expect in the settlement to come from the ICJ. This will be our last broadcast for the rest of this year. Until next year, I think January 8th, we'll be back on the air again, because everyone in the office needs a vacation. And this is the time to take the vacation to be with their loved ones and so forth. So Merry Christmas to all our listeners, far and wide. And Merry Christmas to you, Ms. Street.
Thank you so much. Merry Christmas to you too.
Thank you very much.
Thank you.